I talk quite a bit about the limitations of the federal government and the need for the states to reassert their power to control their creation. Consider the number of federal agencies that do not legally exist, the fact that the Supreme Court does not issue rulings but offers opinions, and don't forget about the fact that the states created the federal government, not the other way around. All of this points to a dangerous and illegal centralization of power in the federal government. So you can probably imagine my elation to find legislation proposed in my own adopted home state that codifies them doing exactly what I said all of the states need to do: regain control of their creation in Washington, D.C. So let's take a look at this legislation, see what lessons we can learn from it, and maybe push representatives in the other states to join in this march toward liberty.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. I am glad you're here. I'm looking forward to bringing you this episode on this interesting piece of legislation. I haven't been this excited about a piece of legislation in a long, long time. Now, this is a fairly long episode. I've got a lot to cover. Now, I've got some interesting things I'm lining up for the Constitution Study, and I'm going to leave those to the end because I've got a lot to cover, and I want to dive right into this legislation out of the state of Tennessee. I've read several pieces of legislation, but this one struck me for a few different reasons. First, the list of findings in Section 3 is a masterclass in the constitutional republic that is America and in the role and duty of the states in such a union. Then Section 5 lists the standards by which federal actions will be judged, while Section 8 lists the processes for challenging those actions and showing a good understanding of our history and the seriousness of any such challenge. Well, there are two bills in the Tennessee General Assembly, one in the House and the other in the Senate. As of this episode's recording, both bills are identical. So for this episode, I will use the House version, HB 726, as my reference. Let's start with the findings of the General Assembly of Tennessee. By far the largest section of this legislation is Section 2, listing the findings of the General Assembly. Now, since the nullifying of a federal action is a big deal, it makes sense the justification for doing so should be large as well. This section starts with the Tennessee Constitution. Article 1, Section 1 of the Constitution of Tennessee declares that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. For the advancement of those ends, they have at all times an unalienable and indefeasible right to alter, reform, or abolish the government in such manner as they may think proper. The Tennessee Constitution starts right where it should, noting that power doesn't come from the government, but from the people. We create governments. We give them authority, and they are there to secure our peace and happiness. Article 1, Section 2 of the Constitution of Tennessee declares that government being instituted for the common benefit, the doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. After pointing out that all power comes from the people, Section 2 of the Tennessee Constitution points out that not resisting arbitrary power and oppression is absurd. This is important since the entire purpose of this legislation is to resist arbitrary power exercised by the federal government. Next, HB 726 takes a look at the Constitution of the United States. When we, the people, ordain and establish the Constitution of the United States of America, the people of the states granted only specific, limited powers to the federal government, with those areas of federal powers being enumerated in Article 1, Section 8 of the Constitution of the United States. It had appeared that the concept of the federal government having limited and enumerated powers was dead. Today, however, we have several states standing up and reviving that doctrine, and Tennessee is poised to jump into that fray. They start their argument with what has become a unique look at the separation of powers doctrine. Articles 1, 2, and 3 of the Constitution of the United States, respectively, vest the legislative, executive, and judicial powers to and within separate branches of the federal government, known as horizontal separation. such that lawmaking powers are vested only in the legislative branch of the United States Congress, that enforcement powers are vested only in the executive branch, the president and executive agencies, and that judicial powers are vested only in the judicial branch, the Supreme Court of the United States and other inferior federal courts created by the United States Congress. Why is this horizontal separation of power so important? The horizontal separation of powers in the Constitution of the United States reflects the understanding that our federal founding fathers had derived from both scripture and experience that sinful man could not be trusted to always be virtuous and public-minded, and as such, they did not want undue power to be combined in any branch of government where, if left unchecked, it could become tyrannical. The framers of the Constitution understood how dangerous the concentration of power is. Or as Lord Acton is often quoted, power tends to corrupt and absolute power corrupts absolutely. As we so often point out here at the Constitution Study, there's much that Congress does that's not authorized by the Constitution. Nothing in the Constitution of the United States permits Congress to delegate or confer any lawmaking power to any other branch of government because it has no enumerated powers to create lawmakers. When the president and federal courts are vested respectively with the executive and judicial powers, neither of those branches are granted the general power of lawmaking. Therefore, no person, agency, or department of any other branch of the federal government, not even the Supreme Court or the President of the United States, has any lawmaking power under the Constitution of the United States. This bill takes its first jab at the federal government by pointing out the violations of the horizontal separation of powers. Article 1, Section 1, Clause 1 of the Constitution of the United States says that all legislative or lawmaking power is delegated to Congress. The president cannot make law via executive order, and contrary to popular belief, neither can the federal courts, not even the Supreme Court. And Congress has no authority to delegate its lawmaking power to others. Well, that should be plenty to nullify Congress's attempt to shirk their responsibilities. Placing lawmaking power in the hands of unelected bureaucrats is the kind of taxation without representation that our founding fathers listed as a reason to declare independence. Now, if subsection 6 puts the proverbial knife into the federal government's violation of the separation of powers, subsection 7 gives it a good twist. In Article 1, Section 7, Paragraph 2 of the Constitution of the United States, the text describes how federal laws are to be made. Bills must be passed by both houses of Congress and then approved by the president or by a presidential veto by Congress. This is the only method of lawmaking under the Constitution of the United States. Thus, contrary to popular opinion, federal executive orders, federal agency rules and regulations, and federal court opinions are not laws at all, and they are certainly not settled law or the supreme law of the land. Instead, any action by the executive branch or the judicial branch that purports to be law or that purports to be treated as law is a usurpation of powers not delegated to it. This subsection is music to my ears. Not only does this legislation point out that only Congress can make laws, but it goes so far as to emphasize that federal executive orders, agency rules, and court opinions are not law. In fact, when the executive or judicial branch claims their actions are law, they are usurping the powers the people have placed in Congress. Now, subsections 8 and 9 expound on this error. It is not uncommon for Congress and the federal executive branch to erroneously elevate federal court opinions to the status of law, sometimes even regarding court opinions as having amended the language of the Constitution of the United States. It is not uncommon for Congress and the federal courts to erroneously elevate federal executive orders to the status of law, sometimes even regarding executive orders as having amended the language of the Constitution of the United States. Now, if two wrongs don't make a right, then two violations of the Constitution cannot be just. Even though the three branches of the federal government may treat as law court opinions and executive orders, that does not make them so. The idea of separation of powers is not just a federal one, by the way, but part of the Constitution of the state of Tennessee as well. The principle of separation of powers is so innately representative of a Republican form of government that the Constitution of Tennessee, Article 2, Sections 1 and 2, upholds and reinforces this principle of horizontal separation of powers within the three departments of our Tennessee state government. Now that we've gone through the horizontal separation of powers, is there a vertical one? When creating a federal government by ratifying the Constitution of the United States, the people and the states also designed a second and more important separation of powers. that being a vertical separation of powers between the superior sovereign states and the inferior federal government. This is another subsection that raises my spirits. To read a state legislature recognizing that it is superior to the federal government is something I wasn't sure would happen in my lifetime, yet here it is. Can the Tennessee General Assembly prove this point? A vertical separation of powers was explicitly set out in Article 1, Section 8 of the Constitution of the United States, wherein only limited enumerated lawmaking powers were granted to the federal government. This vertical separation of powers was also incorporated into the United States Bill of Rights, whereby in the First Amendment, Congress was specifically denied lawmaking powers within those fields listed in the First Amendment. In the Ninth Amendment, the federal government was specifically prohibited from interfering with rights not mentioned in the Constitution of the United States. And in the 10th Amendment, the federal government was specifically denied powers not delegated to it in the Constitution of the United States. I'm not sure that subsection 12 is entirely correct. While Article 1, Section 8 of the Constitution enumerates powers for Congress and the First Amendment places limits on that power, I don't see how that sets out a vertical separation. Subsection 13, item C, on the other hand, does point out the separation of powers the Federalists claimed during the ratification debates. Now, the General Assembly of the state of Tennessee looks at judicial evidence to support their claim to nullify certain federal actions. Any federal action that violates the horizontal separation of powers imposed by the Constitution of the United States or that exceeds the jurisdictional limits imposed by the vertical separation of powers is therefore void, since the Constitution of the United States is the supreme law of the land. A law repugnant to the Constitution is void. An act of Congress repugnant to the Constitution of the United States cannot become law. The Constitution supersedes all other laws, and the individual's right shall be liberally enforced in favor of him, the clearly intended and expressly designated beneficiary. It's from the case of Marbury versus Madison from 1803. I've pointed out for years that unconstitutional laws are void, but it's nice to see a state legislature do so as well. After all the times people have misquoted Marbury versus Madison, it's nice to see it properly used here as well. There's more, though. An unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be used as a legal cause of imprisonment. That's from ex parte Siebold. An unconstitutional act is not law. It confers no rights. It imposes no duties. It affords no protection. It creates no office. It is, in legal contemplation, as inoperative as though it had never been passed. That's Norton v. Shelby County from 1886. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. That's Miranda v. Arizona from 1966. If an unconstitutional law is void, how can someone be convicted of violating it? If that act is not law, how can it create an office or an agency for that matter? This basic understanding of the supremacy of the Constitution of the United States is foundational to understanding the proper role of nullification. As Thomas Jefferson explained in the Kentucky Resolution of 1798, whensoever the federal government assumes undelegated power, its acts are unauthoritative, void, and of no force. He added, where powers are assumed which have not been delegated, a nullification of the act is the remedy. That every state has a natural right and duty in cases not within the authority of the Constitution to nullify of their own authority all assumptions of powers by others within their own state boundaries. The Constitution of the United States binds federal lawmakers by oath to support the Constitution, and when they fail to do so, the rightful remedy is for states to nullify their usurpations and to declare their acts void. The Tennessee General Assembly even points back to Thomas Jefferson's Kentucky Resolution to show that unconstitutional federal actions are void. The legislation has more findings, but to avoid beating a dead horse, I want to move on to what standard the state would use to evaluate these federal actions. How the state would determine if a federal action is unconstitutional is one of the three pillars upon which any nullification legislation must stand. When evaluating a federal action, the General Assembly shall consider the plain reading and reasoning of the text of the United States Constitution and the understood definitions at the time of the framing and construction of the Constitution by the framers before making a final declaration of constitutionality as demonstrated by the ratifying debates in the several states, the understanding of the leading participants at the Constitutional Convention, The understanding of the doctrine in question by the constitutions of the several states in existence at the time the United States Constitution was adopted, the understanding of the United States Constitution by the first United States Congress, the opinions of the first Chief Justice of the United States Supreme Court, the background understanding of the doctrine in question under the English Constitution of the time, and the statements of support for natural law and natural rights by the framers and the philosophers admired by the framers. Look at the list of standards the state would have to use to evaluate federal actions. The ratifying debates, the Constitutional Convention, the First Congress, etc. Not a bad set of standards if I say so myself. In Section 6 we read, "It is declared that federal laws, federal executive actions, and federal court opinions must comply with the jurisdictional limitations of the United States Constitution. It is further declared that any federal action outside the enumerated powers set forth in the United States Constitution are in violation of the peace and safety of the people of the state, and therefore said acts are declared void and must be resisted. The proper manner of resistance is a state action of nullification of the federal action." If the proper manner of resisting unconstitutional actions is nullification, how would that work in Tennessee if this becomes law? This legislation establishes several methods by which an unconstitutional action could be nullified. The governor may, by the governor's own executive authority, issue an executive order nullifying the same, whereby all executive departments of that state are bound by said order. First, the governor can issue an executive order nullifying a federal action, but that would only affect the executive branch of the state. Any member of the General Assembly may introduce a bill of nullification in the General Assembly. For any such proposed bill of nullification, the bill is not subject to debate or passage in committees and proceeds directly to the floor of each house, where said bill, within 5 legislative days, be scheduled for debate on the floor of each house, and thereafter, within 3 legislative days after the debate is closed, shall be presented for a roll call vote on each floor. The bill, if passed in the same manner as other general law, has the force and effect of law and becomes effective immediately upon enactment. The time constraints listed in this subdivision may be changed by majority vote of any house of subsequent General Assembly. A member of the General Assembly can introduce a nullification bill. This legislation would be fast-tracked through the process, since it would bypass the committee process and go directly to the floor. Also, limiting the time before the bill can be debated and how long after the debate a vote must be held means that someone cannot use the process to delay voting on the bill. Any court operating under the authority of the Constitution of Tennessee may render a finding or a holding of nullification in any case of which it otherwise has proper venue and jurisdiction, wherein the parties to said case will, upon final judgment, be bound thereby in the same manner as in other cases. Even the state courts could nullify an unconstitutional federal action, at least for the case they're currently hearing. That means that all 3 branches would have the authority to nullify a federal action within their horizontal separation of powers. But that's not all. Any combination of 10 counties and municipalities may, through the action of the executive or through the action of a majority of the governing legislative body, submit a petition of nullification to the Speaker of the House of Representatives, with a copy to the office of the Attorney General and Reporter, and upon satisfactory proof that said petitions are valid, the Speaker of the House of Representatives shall proceed to introduce the bill and follow the same methods and protocols as described in Subdivision 2. What if no one in the General Assembly introduces a nullification bill? Then what happens? Well, a group of counties and municipalities can petition the General Assembly, and if enough valid petitions are made, the General Assembly now has a nullification bill they must treat like any other. Still, this legislation isn't done yet. Since HB 726 states that all power is inherent in the people, they get a chance to bring a nullification bill to the General Assembly as well. The signed petitions of 2,000 registered voters of the state may submit a petition of nullification to the Speaker of the House of Representatives, with a copy to the office of the Attorney General and Reporter, and upon satisfactory proof that said signatures are valid, the Speaker of the House of Representatives shall proceed to introduce the bill and follow the same methods and protocols as described in Subdivision 2. Said voter petitions must not be submitted individually, but said petitions must be coordinated and compiled in batches by county of voter registration of not less than 25 voters per county in a bundled batch. In other words, all components of the state have the power to call for a nullification of unconstitutional federal actions. I know this was a pretty long episode, but there's so much good in this relatively short piece of legislation, I couldn't help but bring you the details. Of all the legislation I've reviewed here at the Constitution Study, this has to be one of the best. Yes, there are one or two small things that I'm not sure of, and I would like to see some punishment for state employees that enforce a federal action that was nullified by the state. But overall, this is a very nice piece of legislation. Who knows? If the other 49 states use this legislation as an example, we could see a return to the land of the free and the home of the brave in our lifetimes. I can't tell you how many times someone comes to me and says, there's nothing we can do, nothing will ever change, it's just going to go on and on. Well, here's something that could change. Think of the drastic change this would make if the people and the counties and the state government of the state of Tennessee could actually nullify, legally nullify the actions of the federal government within the state if those actions go beyond the constitutional limits placed on the federal government. Just think of it, the governor saying these executive orders are not valid and we won't enforce them. Or the court saying, we know the Supreme Court said this, but the Constitution says that, therefore that's how we're going to find. And of course, the legislatures get their chance, but I love the fact that they include the counties and the municipalities and the people as being able to petition to have a federal action reviewed for constitutionality. I have to say, I'm really impressed by this legislation. I've gone so far as to reach out to legislators, not only my House rep and senator, but the sponsors of the legislation in both the House and the Senate. I think it's that good. I think it's that important. Now, I'm no fool. This isn't done yet. This is simply proposed legislation, and there's no guarantee that it'll be passed. But think about it. What if the other states started copying this type of model? What if the other states started looking at what the Congress, federal Congress is doing, what the executive branch is doing, what the judicial branch is doing, saying, wait a second, you had no constitutional authority to do that. Here is our proof. Once we've shown it to our legislature and they agree with it, that action is null and void within the boundaries of the state. Please don't leave Tennessee out here alone. I know other states are working on other forms of nullification, sometimes on specific topics like gun rights or marijuana laws. And there are a couple that are talking about nullifying federal executive orders. This, to me, of all the legislation I've reviewed so far, is not only the most comprehensive, but the most well-grounded legislation for nullification by the states that I can think of. So I hope you'll look at this, and I hope you'll start talking to your state legislators. Show them that this can be done. Show them that it is constitutional and legal. Show them the importance of doing it. I doubt we'll get all 50. But really, how many does it take before we start having a huge impact on Washington, D.C.? How many times have I told you, you start local and then work your way up to Washington? If we get our counties being constitutional, they eventually impact our states. Well, here is a state that's been impacted. What are you doing to help impact your states? And again, once Tennessee does this, we get a few other states to join in, and suddenly we have a tremendous impact on Washington, D.C. And that, ladies and gentlemen, should excite all of us. It should light us all up that, yes, it is possible for America to return to the land of the free and the home of the brave in our lifetimes, but it's not going to happen unless we do some work. That means meeting with your state legislators. It means meeting with your governor. It means pushing them to either propose legislation like this or support it. I don't mean showing up saying, please do. I mean push. I mean push hard. Let them know that they work for you and this is what you expect of them if they wish to keep their jobs. Now, if you want more, head to the website, constitutionstudy.com. You can find the written article. I've got links in there to the actual legislation. You can find other resources there as well. Now, I am working on something new for the Constitution Study. You may remember I set up a website called Constitution Scholars. Well, it really hasn't gotten enough traffic, and I'm shutting it down. But that doesn't mean I'm over with the idea. No, I'm building within the Constitution Study website something new. And the first part of that deals with education, specifically a mini boot camp. I want to help you build a foundation for your study that will stand not only the weather, but the test of time. As Jesus said, one man built his house upon the rock, one man built his house upon sand. I'm trying to help you build that rock you can build your study on, one that will survive challenges, questions, yet is flexible enough to understand you may not be right all the time, so it'll take in new information. Now, I'm still in the planning stage. I'm actually working here to get a recording of this event, which I will then put up on the website. But I hope you'll keep in touch. The best way is to join one of the mailing lists, either the newsletter or the insiders. That's where I'll keep you up to date on what's going on with this new program. And it's only step one of others. I want to do a full-fledged boot camp. I want to have an in-person, all-day event where we get together and have a boot camp. I want to establish some communication methods, some action steps that we can all work on. But again, you can find all that information at constitutionstudy.com. And if you sign up for the mailing list, you'll get notified as this stuff starts coming about. Most of all, I hope you're excited about this legislation as I am. I can't remember the last time I was so giddy about a piece of legislation. Hopefully you're just as giddy about this episode and what we've been talking about. Most of all, I hope you come back and visit. Maybe even bring a friend or two as we join here together to read and study the Constitution right here on the Constitution Study.
Love the neighbors and have a few good friends.